Hi, I'm Jody.
Hi, I'm Zack McKee.
And this is the Beargrass Thunder interview for Circuit Court Judge, Division 10. So, Zack, why you decided to run for this judge position, as well as who can vote in this Division 10 election?
Okay, if I can start with who can vote in Division 10, it's all of Jefferson County. So anyone needs to do is just flip over the ballot and you'll see all the judicial candidates on the back. My name is second. It's Division 10. Division 10 only means the seat number that your university will be sitting in. It doesn't mean anything about that it's not countywide or it's a certain district. It's literally open to everyone in Jefferson County. All you have to do is just flip over the ballot. Then about myself, so my name of course obviously is Zack McKee, and I'm originally from Paris, Kentucky, which is a small town just outside of Lexington, about 15 minutes outside of Lexington. When I grew up, my mom was a single parent. It was just me and my brother. And I am a first generation college graduate as well as a law school graduate. So my mother, she's been employed at a place called Avient, where they make car tires. She's been doing it for like 26 years, and that's what she did to basically raise us. I went to law school at the University of Louisville, and during law school, I received a limited license to practice law, and I represented victims of domestic violence, low-income victims of domestic violence who couldn't afford an attorney, get representation or get a domestic violence order. Then after that, I became a judicial staff attorney, which means every judge in Kentucky gets to hire their own lawyer. So you help them do legal research, type orders, whatever it is that they need you to do. So I did that in Fayette County initially, then I transferred and did it here in Jefferson County. And then after that, I opened my own practice. And in my practice, I do family law, I do criminal law, I do personal injury, I've done bankruptcy, I've done probate, I've done appeals from district court to circuit court. So like if you have an issue in district court and you don't agree with the ruling, you can appeal it to circuit court. So I've done that. I actually have an oral argument this coming Tuesday in Hardin County for an appeal that's from district to circuit. So I've done that. I've done appeals from circuit to the Court of Appeals. I've won a few cases in front of the Court of Appeals. I've been in front of the Kentucky Supreme Court. I've had the Kentucky Supreme Court actually depublish a published opinion from the Court of Appeals. So that's the Kentucky Supreme Court. And I practice in federal court. I do, actually I had to answer a response to a summary judgment motion due yesterday that I did up until the last minute. So I practice in federal court, 1983 civil rights violations. I practice obviously in state court. I'm a guardian ad litem. I represent children whose parents are accused of abuse and neglect. I'm running because I'm running off justice, equality, and fairness because I believe that I know my lens as an individual, based off how I was raised, based off what I know the law, that I know my lens and how I view life, and I know that I can bring exactly that justice, fairness, and equality. I think that if you don't have justice, you don't have equality. And if you don't have equality, you don't have fairness. So I think that I'm trying to bring all three to the bench. I know that I will bring all three to the bench.
First off, thank you for sitting down with this interview. A lot of our viewers, we are wanting to learn more about how we can get involved with the judicial system just as private citizens, and just wanting to learn more about how to advocate for some of these issues. And so one of the questions that I wanted to ask is, what do you perceive currently as some of the greatest obstacles to justice, if any?
Yeah, that's a good question. I think maybe resources as one of the greatest barriers. And the reason why I say that is because, I mean, you may hear other people say that typically if you got the money to, hire the flashy attorney, the good attorney, then you can get some things taken care of. I think that, there are a lot of attorneys, a lot of good attorneys out here that do a lot of pro bono, that do help, whether it's working for the state or not. For example, I'm a guardian ad litem, so that's like for the state. We don't get paid much to do that type of work. So I think that if I was to answer that question honestly, I would think that that's the main thing that I would say would be resources, because you have the people with a lot of money, and you have the people that are very low income, and you can't expect somebody that's making minimum wage to pay a $2,500 or $5,000 retainer, and the money's going to run out at some point.
Yeah.
And so I think that is probably the greatest barrier.
So our next question is related to the current state of Louisville Metro Department of Corrections, and specifically the amount of overcrowding potentially in these prison populations, jail populations, but also what response do you think that the courts should have to these issues?
Man, that's a good question. I don't know if exactly I can say that the court has to have a response.
Sure.
I mean, obviously there's 17 district court judges and 13 circuit court judges.
Sure.
So I know a hot topic is bail and nonviolent offenses and nonviolent crimes. I believe that the people who are in jail for a nonviolent crime or nonviolent offense, I think that whether it's letting them out on recognizance or really there's different alternatives. You can do security, some sort of secure bail, or where you have someone come in and actually sign for them. So I think other alternatives to actual bail rather than just putting them in jail, especially if it's like, say somebody is charged with a forged check or something. I mean, you don't want them out there stealing, of course, but that's nonviolent. No one was hurt. I think the violent offenders, probably should be more incarcerated and not out, unless they obviously meet their bail or bond or whatever the situation is. I can tell you this as a garden item: until you see a case where you have a 6-month-old baby with 6-week-old recovering or healing rib fractures, and scars, like that's a situation that a baby cannot tell you that the offender is back. So that person, probably shouldn't be, roaming just, free will just to do whatever. But, I think one of the responses is actually, fairly considering bail. I don't want to sit here and say that, I'm running off justice, fairness, and equality. And so that's what I really believe in. I think it's a case-by-case basis. I think that you should look at the facts, you should look at the case, you should look at this person's history, their ties to the community, whether or not they have a job, whether or not they're a single parent. There's a lot of things that you should take into consideration. And so I think to help with the overcrowding, if you're actually looking at it truly as a case-by-case basis, and you're looking at the people, and not just as some machine where this is a typical case, this is what you typically do with this type of offense. I think look at the person, because you could have totally two different people committing the same offense, but your response, whether it's to grant them bail or release them on recognizance or not, or surety or whatever. I think that that could help with the overcrowding of the jail. I mean, that's one thing that I've talked to everybody about is, another reason why I'm running is I think if you have people on the bench that are going to be honest, that are going to be transparent, that are going to be fair, that are going to be open, I think that's a start, and again, I know I've been saying it maybe 2 or 3 times, but I keep saying it to emphasize it. It has to be looked at on a case-by-case basis. You have to look at who the person is and the facts behind it. And so if there's people over there for nonviolent offenses, I mean, what good is that doing if the jail is overcrowded? Then what that leads to someone getting hurt, someone getting killed, then it leads to a lawsuit against the jail. And so it's a needless cycle. So I think it starts with, honestly looking at violent versus nonviolent crimes, looking at, bail, looking at whether or not there even needs to be, some sort of cash bail, for that person, because not all the time is that $1,000 to somebody, could be $100,000.
Yes.
And so, you instead of doing that, you could do a surety. You can do, there's other alternatives other than just, I'm gonna make you pay $1,000 if you make a minimum wage.
Yes.
And you stole, a pack of bread and milk from the store to feed your kids.
Yeah.
So I think you gotta keep it. You really have to look at the facts.
Yeah. How would you prepare to handle cases that maybe you are unfamiliar with a certain area of the law as a judge?
That is actually a very good question. And so if it's an area that I'm unfamiliar with, I think how I will approach it is one, that you can ask the attorneys to brief the issue. Two, once you have them brief it, you obviously, it's your job as a judge to read it, and then you can perform your own individual research. So what I do know from being a former staff attorney is that the judges and the staff attorneys all get a Westlaw account. So Westlaw is basically a program where you can find pretty much cases in all 50 states, in federal court as well, United States Supreme Court. It's supposed to be basically a kind of like a library of law, of decided cases, of statutes and things like that. So from my experience, I would go to the statute at issue. Typically the statute cites, or it has certain cases maybe that's already been decided interpreting the statute. And so, you have to read the cases, see how the Court of Appeals, the Supreme Court is looking at the cases, and then look at the facts, apply the law to the facts. And so I think that to me is to ensure that people are treated fairly, and to ensure that there's justice and equality. I think that that's what you have to do. You have to look at it with, an equal lens, even footing, brief it, cite the cases correctly. Like don't add in words, but just cite the case, what it says, and apply literally those facts that you have in front of you with the law to issue a fair judgment. So I think that any issue, no one person ever goes to the bench knowing every single thing. And so I think it's the person who's going to actually take the time, whether it's on the weekend, whether it's on, after 5 o'clock, that's actually going to literally do the research themselves, and or with the help of a staff attorney, but typically themselves as well, so that they can really issue a fair ruling.
It's incredible to hear that you want to do stuff theoretically off the clock. Right. So, that's a lot of things that I've heard and just seen growing up. It just seems like a lot of cases seem to be rushed, or it doesn't seem to be researched as well as some of these others. So that really does mean a lot that you want to take time to look into these cases in depth.
I appreciate that, and that's actually, as a staff attorney, I've done that. I've been at the courthouse when I was a staff attorney in my office at 8 or 9 o'clock at night. Either whether it's doing research or whether it's helping type an order or whatever the situation is. But at the end of the day, we're supposed to be helping people. When you get the robe, or if you have the robe, it's not about power, it's about helping. And so what better way to help people but to get it right and to do it right the first time.
Wow. What do you believe to be the root cause of high numbers of juvenile offenders, and what changes do you think the court system can make to theoretically reduce those numbers?
That actually is a good question. I know that when it comes to the root cause of juvenile issues, I don't know if we can pinpoint an exact root cause. Is it juveniles following the footsteps of other juveniles? I know I spoke at Atherton High School, and I was heartbroken to find out that the students that I was speaking to, at least all of them in the room had been shot at, and a couple of them had actually been shot. And so, but listening to them and what they, their stories and what they've been told, it seems like some older people that are over 18 have kind of like infiltrated them to have other juveniles do certain things that they probably shouldn't do and commit crimes or whatever. And so one thing that I gathered from that is that there were adults telling kids to shoot at so-and-so or whatever, or having them do that. And so if you're a child and you're grown up thinking that that's normal, that's what you're supposed to do, maybe they think that that's normal, that's what you're supposed to do. I'm not saying that that's the root cause. I'm saying that that's just what they informed me in speaking to them. And, that was very heartbreaking and disturbing. As far as what we can do, I know that these same students complained about not having resources, not having programs, certain things being taken away from them, where the place where they hung out, or certain parks, whatever the situation was. So I think that in making sure that juveniles do have resources, making sure that we're pouring into them more, in school or even, at church or, wherever they're going to be at. I think that, actually, speaking to the kids, in a way, not necessarily saying like they're not speaking to them necessarily as an adult, but speaking to them in a way that they can understand it, because they, at the end of the day, they still are juveniles. And I think sometimes if a kid makes a mistake, we want to speak to them like they're an adult, but let's speak to them in a way that they're going to understand it. So I think that that's, a starting point. I know at least, when I speak to kids, so I'm a board member at the Northeast YMCA, and I'm a board member of this program called Spark Hope. It was started at Northeast Christian Church, and we're focused on helping single parents. And so even at the Northeast YMCA, I've donated, programs for kids. I've been doing it since like 2017. And so, to me, I am about, pouring into the youth. Whether it's Black Achievers, I've donated to Black Achievers virtually almost every year. And so making sure that we pour into the youth, whether it's with those, type of programs or, just making them want to do I don't want to say do the right thing because it sounds corny. Yeah. But, I mean, you can live a normal life. You can, be a carpenter. You can, be a mechanic. I mean, you don't have to be an attorney, but you can, earn a good living, actually work, and then, getting involved in or being involved, whether you forced into it or not, and, certain other things that probably not going to lead to a productive life. Right. But at the end of the day, what I do know is that I personally can't see how we can blame a kid for their situation because they was born into it. Yeah. So I think as adults, as people, we should actually just try to connect with the youth, try to, spend time with them, educate them, inform them, love them. Yeah. I think that could be part and parcel of how we could end some of the violence. And I mean, it is bad, obviously. It's pretty bad.
What I like hearing is that you want to, like, outside of just the judicial system, uplift the community rather than only focus on punishing the offenders. Right. That's really nice to hear.
Well, I think when I did speak to those students, like, they, knew I was an attorney, and, I was able to speak to them in a way where the teacher was like, they really opened up to you. Like, they have not opened up like that, but it's just connecting, right? I may have on a suit, may have on a tie, but I'm still a human. And I think that at the end of the day, too, I think that if the youth see you as being genuine and real and actually caring about them, then I think they will be inclined to listen. And and as far as like the court system and the youth is concerned, so if there is a case with involving the youth, typically, or mainly, it'll probably be in district court or start in district court. So it wouldn't be too often that I would have to interact with youth. But one reason why I am running for circuit court is because as a guardian ad litem, I have seen children who have lost their parents. So I believe in rehabilitative justice, in that there is a lot of I've seen it far too often where a kid literally taken away from their parent, or the parent loses the kid, or rights terminated, or whatever the situation is, or they're in foster care for an extended period of time because of drug addiction. But I think that if we are able to give these people, and they have an ongoing criminal case, and so if they're not complying with the criminal case, or if they get a heavy sentence or whatever, then obviously the kid is the kid can't go to jail with them, so they lose their parent. And it's like, I think that giving people resources, giving them opportunity to, let go of their addiction, to live a productive life, whether it's speaking to them from the bench, or whether it's putting them into programs, or really encouraging them, wanting to actually see them through. I think that's another reason why I'm running, is because I want to be able to affect that. I want to be able to make sure that the family unit is kept together, and kids aren't losing their parents.
If you observed a party in the courtroom being poorly represented by either an unprepared or ineffective lawyer, how would you handle the situation as a judge?
That's actually a very good question. And I think that, you got to look at two situations, two things. One, what is the case on in front of you? What is it? Is it a criminal case? Is it a civil case? Is this, is it somebody potentially going to be going to jail? What is the situation?
Yeah.
And so then, you got to look at the attorney's perspective too, is that, what is their situation? Did something happen to their family last night or the week before, or are they, in some sort of situation that they're struggling with? So I think the proper thing to do, the most proper thing to do would probably be to end the, not necessarily end the hearing, but pause the hearing. You can actually have the person come, whether it's probably the lawyer, have the lawyer come in chambers, or white noise, which means you come to the bench and you just hit the little white noise, nobody can hear what you're talking about. And just basically you could pass it. Or I probably really would inquire with the lawyer if they were okay with what was the situation, what was going on. Are they, do they want a pass date? Do they need a pass date? And more than likely, probably just pass it to another date. Especially if you don't. That's the other thing about being a judge. You never know what has happened to anybody. When they walk into your courtroom, you don't know what day they had that day. You don't know if they lost a relative. You don't know if they lost a job. You have no idea. And so I think that, being considerate, of people's, emotional state, mental state, I think that's something else that, as a good judge would do. And so I think me personally, that's exactly what I would do is, you already know what the case is about. And consider, look, if we keep going forward, then X, Y, and Z is going to happen. It's not going to be good for you or the client. You could result in a bar complaint or whatever. And so I think the most efficient professional thing to do would be to speak to counsel, white noise, so no one can hear what we're talking about, or just go to the back and, that's no okay, or just pass the case. And then ask the client if they want the case to just be passed, and give them more time or whatever.
Right. Thank you for that. And our last question is, why should voters support you over other candidates for judge?
I think as far as for my race, I think that voters should support me because I bring a different viewpoint and I bring balance. So I can say that I practice in criminal court, I practice in civil court, I practice in federal court. And so what I mean by civil court is, like, for example, whether it's a wrongful death case, whether it's a 1983 case, any, some sort of lawsuit, participate in depositions, discovery process. So I've done all of that. As well as in criminal court, I've done assault 4, I've done DUIs, I've done wanton endangerment, I've done a plethora of not suppression, but trafficking, possession. I've had suppression hearings, won many suppression hearings, just different types of criminal law and civil law. So I have that experience. And again, and the other thing that circuit court judges do is that they hear appeals from district court. And I've done that. So I've appealed from district to circuit. So I'm familiar with what that entails, and I've appealed from circuit to the Court of Appeals. So I'm pretty, I believe that I'm the most well-rounded. And I know I'm the most well-rounded. And then again, I have a different perspective and lens and view on life and towards people. And so I don't think that, I practice in other counties outside of Jefferson County. So whether it's Hardin County, Scott County, Fayette County, Bourbon County, Meade County, like I literally have practiced in a ton of states all over Kentucky, and just getting that experience, from whether, how they run their courtrooms, how the system works. I think I can bring that to the bench as well. And so to me, my lens is one of, again, justice, equality, and fairness, and treating people as people. Everybody is human, not, being rude, not being mean, speaking to attorneys and clients respectfully, treating everybody respectfully, and making sure at the end of the day that everyone feels and knows that they've been treated fairly. At the end of the day, the law is going to come down one way or the other, but you want to make sure that the law is applied that makes sense to everyone, that they know when they leave the courtroom that, okay, I get it, this may not have went my way, but the law does say this, and then this is fair, and I did have an opportunity to argue, or vice versa. The law does say this, the judge got it right, this is fair. And so, I've been a part of cases where both attorneys, where we talk afterwards. It was like, the judge got it right. At the end of the day. So it's like, I think that you want to make sure that the people know that they actually were heard. And so with my qualifications, with my background, with what I've done, with my personal experiences, with my life, and I have a 10-year-old son that attends Audubon Traditional School. And so, being a father and knowing what, what told, as a parent, what other parents may feel seeing their kids in trouble or whatever. And so I think I just bring a different lens, and I know I bring a different lens. Thank you for the interview today. I had a great time speaking to you. Please go to my website, McKeeforJudge.com, to learn more about me. And please, I would greatly appreciate your vote May 17th, 2022. I have a primary election. Please vote Zack McKee. My name is in the middle. Turn over the ballot, Division 10. Thank you.